Prashanti. The current H1 cap max out. These are questions from someone from a Facebook group, and the questions we've received via email. So the question is the current H1 cap max out is May 2024, and I got approved 140 this month from employer A, but I plan to switch jobs with employer B. If I file an H1B extension based on the approved I-140, I may get 3 years until 2025. If employer A withdraws the I-140, what will happen to the H1B? And would the 3 years approval valid, or will it be right up to the maximum in 2024?
So basically, if you have an I-140 approved, then you get 3 years of extension on your H1. It doesn't matter even if you change employers, you still get, and even if your I-140 gets withdrawn, you still get that 3 years approval on your H1. And you can use the maximum 6 years until 2024, and then use the 3 years, keep getting 3 years extensions. So, but it really doesn't matter, because an I-140, if you have an I-140 approval, you get 3 years into eternity. You keep on getting 3 years extension. So there's no purpose in using the remaining time really on your 6 years H1, which is what your question is. And your other question was, again, what happens if my employer withdraws the I-140? That doesn't affect your ability to get extensions for 3 years, because you can file another I-140 through another employer and still maintain the priority date.
So, is it mandatory, for example, the I-140 is withdrawn by the previous employer, and is it mandatory they continue to have an active 140 with the new employer?
So as long as at the time of filing your H1 extension for 3 years based on the I-140, at that point of time, your I-140 should be valid. It shouldn't be withdrawn. But after that, if they withdraw it, it's not like you fall out of status. You don't. You continue to be on your 3 years extension. And it's not mandatory that your new employer file a new I-140 for you immediately. Obviously, at some point, you want that I-140 to be filed so that you get a green card. But it's not mandatory that they file it immediately.
So I have a follow-up question here. Now, the previous 140, as you stated, the previous 140 can be used to extend the H1. Now, what happens if the priority dates get current and they don't have a new 140 from another employer? Can they still use the old 140 to file the permanent residence green card?
Right. So only for purposes of priority date retention and filing of a H1 beyond the 6 years, can you use I-140 that has been withdrawn. Remember, withdrawn, not revoked by USCIS. But for the sake of actually filing a green card, you would then have to have a valid I-140. And of course, your priority date has to be current. And in your example, the priority date is current. So no, you cannot file a green card. You'll have to file a labor cert and file the I-140, and then port the priority date of the withdrawn I-140 to your new I-140. That's the process you'll have to follow, and by the time that date, which is current, it may not be current anymore, because the labor cert takes almost a year to get approved. So it's important that at any given point of time, you have a valid approved I-140, so you can make use of this situation if the priority date suddenly gets becomes current.
Okay. Thank you for answering that question. Now, if you, it looks like this is a little complex. I suggest viewers out there to reach out to Prashanti Reddy if you need consultation. The information is right down in the description and also on a ticker on this video screen. Thank you.